Two words said under oath in January. No retribution. That's Kash Patel at his own confirmation hearing, describing exactly how he'd run the FBI if confirmed as director. Months later, in a separate proceeding, a federal lawsuit was filed by three senior FBI officials, a combined 6 decades of service between them, alleging something specific, not a vague accusation, a specific claim with dates, with names, and with a quote they say came directly from Patel himself. Today, we're not doing hot takes. We're putting the confirmation transcript next to the later testimony, next to the lawsuit's actual language, and letting you see where they line up and where they don't. Quick context, timeline fast version. January 2025, Patel's Senate confirmation hearing. He makes several specific written and verbal commitments: no politicization at the FBI, no retributive action, and this exact phrase, quote, "No one will be terminated for case assignments." February 20th, 2025, Patel is sworn in as FBI director. Throughout 2025, a series of senior FBI officials, including the former acting director who ran the bureau during the transition, are removed from their positions. Late 2025, early 2026, a federal lawsuit is filed by 3 of those officials. Separately, in multiple committee hearings, Senate and House, members from both parties questioned Patel directly about the confirmation hearing language versus what actually happened. That's the timeline. Now let's get into what's actually written down. Here's what a lot of the clip coverage missed, because it isolates the shouting moments and skips the actual document language. Start with the confirmation hearing itself. In his written responses to the Senate questionnaire, Patel's exact words were, "Personnel decisions shall be based on performance and adherence to the law, and every FBI employee will be held to the absolute same standard, and no one will be terminated for case assignments." That's not a paraphrase. That's the language multiple senators later read back to him, word for word, from the official record. Now, what nobody's covering as closely, in a later hearing, a member directly asks Patel whether he ever, in whole or in part, terminated or disciplined an FBI employee because of their work on an investigation involving Donald Trump or January 6th. Patel's answer on the record is, no one at the FBI is terminated for case assignments alone. Notice the word alone. That word wasn't in his original confirmation promise. His original promise was no one will be terminated for case assignments, full stop. In the later hearing, when pressed multiple times for a yes or no answer to a version of that question without the word alone attached, he does not give a direct yes or no. He restates the alone formulation repeatedly across at least 5 separate follow-up attempts by the questioner in that hearing. That's a linguistic shift worth sitting with for a second, not because it proves anything on its own, but because case assignments alone and case assignments are 2 different legal claims. One says an assignment was never a factor, the other says an assignment was never the only factor, which technically allows for an assignment to have been part of the reasoning. Second document thread, the lawsuit's specific allegations. Now here's where the paper trail gets more specific. The federal lawsuit filed by the 3 officials, Brian Driscoll, Stephen Jensen, and Spencer Evans, according to the documents referenced across multiple hearings, makes several concrete claims. Claim 1. Driscoll, a nearly 20-year veteran who led the FBI's critical incident response group and held a Medal of Valor, was terminated by letter. The lawsuit and multiple hearing transcripts reference that termination letter as citing Article 2 of the Constitution as the authority for the firing. Language multiple members of Congress noted on the record doesn't correspond to how personnel terminations are normally authorized, since Article 2 concerns executive authority vested in the President, not the FBI director. Claim 2. The lawsuit alleges that Patel personally told Driscoll, in a private conversation, that firing agents tied to Trump-related investigations was likely illegal, but that it was happening anyway because, and this is the phrase used in multiple hearing transcripts citing the complaint, quote, "The FBI tried to put the president in jail and he hasn't forgotten it," unquote. Claim 3. The same lawsuit describes an alleged conversation where a deputy director pressured another official to remove a specific agent, describing the effort in terms of spending political capital to protect that same official's own job. When Patel is asked directly about these allegations in hearings, his answer is consistent across multiple appearances. That matter is under litigation and I'm not able to discuss it. That is a legally standard response. Attorneys routinely advise clients and officials not to discuss pending litigation in public settings, regardless of whether the underlying claims are true or false. It is neither an admission nor a denial. It's a procedural non-answer, and it's important to be precise about that distinction rather than reading it as a confession. The fallout. So what's the actual fallout from these two threads? First, the shift from case assignments to case assignments alone is now permanently part of the congressional record, and it can be, and has been, quoted back at Patel in every subsequent hearing. Whether that shift reflects a change in legal strategy by his counsel, or simply more careful phrasing, or something else, is a fair open question. It is not, on its own, proof of a false statement. Second, the Article 2 language in the termination letter has become its own separate procedural question, independent of the political dispute. Multiple legal commentators have noted that citing presidential constitutional authority in an FBI personnel termination letter is, at minimum, unusual, and it's the kind of detail that a court reviewing the lawsuit will likely examine closely regardless of the broader political narrative around it. Third, because the matter is in active litigation, the discovery process, meaning internal emails, communications, and documents, can now be compelled by a court. That means additional primary documents beyond what's been publicly testified to may become part of the public record over the coming months, win or lose for either side. The pivot must include exact phrase. Okay, but look, we have to be completely objective here. The defense actually makes a valid legal argument, and it's worth taking seriously instead of dismissing it. Patel's consistent position across every hearing is that any FBI personnel action, including these three, was based on failure to meet performance standards or uphold constitutional obligations, not on which cases someone was assigned to. That is a legally coherent defense, and it's worth remembering that performance-based termination and case assignment retaliation can, in a real workplace, both be plausible explanations for the same event. An employee can genuinely underperform while also happening to have worked on a high-profile case. Those two things aren't mutually exclusive, and a termination for one doesn't automatically prove the other. It's also worth noting that "I'm not able to discuss ongoing litigation" is standard legal guidance given to virtually any government official in virtually any administration facing an active lawsuit. Declining to answer specifics in a public hearing is not unique to this case, and it shouldn't be treated as unusual behavior on its own. Prior FBI directors across multiple administrations of both parties have given similarly limited answers when facing active litigation during oversight testimony. Additionally, allegations contained in a filed lawsuit are, legally speaking, just that, allegations. They have not been tested in court, cross-examined, or ruled upon. The plaintiff's account of a private conversation is their account. It has not yet been corroborated by independent evidence, and Patel has not been found liable for anything by any court at this point. That distinction matters, and it's easy to lose in a news cycle that treats "a lawsuit was filed" the same as "a court has ruled." Expert opinion. Employment law attorneys who specialize in whistleblower and retaliation cases have noted publicly that the "case assignments alone" phrasing is a recognized legal hedge, a way of technically avoiding a false statement while not fully denying the underlying concern. But those same attorneys are careful to note that a hedge is not evidence of wrongdoing. It's simply evidence of careful legal phrasing, which is common in any high-stakes testimony, regardless of whether the underlying facts favor the witness or not. Separately, Former DOJ ethics officials have pointed out that the appropriate venue for resolving whether these terminations were retaliatory is the federal court where the lawsuit is pending, not a congressional hearing room. Hearings can surface questions and preserve testimony, but they are not equipped to adjudicate the underlying facts the way a trial, with discovery and cross-examination, is designed to. Real talk: how this affects actual people, not just the politics of it. Every employee in America, public or private sector, is protected, at least in principle, from termination based on protected activity, whether that's whistleblowing, union activity, or in this specific context, federal case assignments tied to political investigations. The legal question at the center of this lawsuit: was an employment action motivated even in part by protected conduct, is the exact same legal question that comes up in ordinary wrongful termination cases involving regular workers, not just high-profile federal officials. That's actually the most important takeaway here, separate from any individual name involved. Courts have long recognized that an employer doesn't need to admit retaliation was the only reason for a termination for that termination to still be found unlawful, if retaliation was a substantial factor. That legal standard, mixed motive analysis as it's sometimes called, applies whether we're talking about an FBI agent or someone working at a mid-sized company in your hometown. Whatever a court eventually decides in this specific case will help clarify how that standard gets applied at the very top of a federal law enforcement agency, and that has ripple effects for federal employment law more broadly. At the same time, and this cuts the other way, the standard also protects employers, including government agencies, from being unable to make legitimate performance-based decisions just because an employee happens to have worked on a sensitive case. If every termination involving someone who ever touched a politically charged investigation were automatically presumed retaliatory, agencies would lose the ability to manage performance at all. Both sides of that balance matter, and that tension is exactly what this lawsuit will have to resolve. Timeline. Here's what to watch for next. The lawsuit is currently in early stages, meaning the discovery phase, where internal communications can be compelled, has likely not been fully completed. Expect additional filings and potentially additional documents entering the public record over the coming months as the case proceeds. Also expect this exact case assignments alone phrasing to come up again in future oversight hearings. It's now a fixed reference point that questioners on both sides of the aisle can cite directly from the transcript. I'll be tracking every new filing and every new hearing the same way we did today. The exact language, side by side, no spin. If you want the next breakdown the moment new documents drop, subscribe and turn on notifications. Drop in the comments, do you think case assignments alone is a meaningful legal distinction, or just careful wording around the same original promise? Let's discuss it below.